And on this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Good to be with you.
Well, it is this time of year, and we normally look back at some of the big agricultural law and tax developments of 2022, and you've got your annual top 10 list, so let's get right to it. Let's go with number 10, and this is a program, of course, here just recently signed in September, at the end of September of 2021, talking about USDA's Emergency Relief Program.
Yeah, Greg, this is a program that it was part of a bill, a larger bill in 2021, but this particular program was $10 billion of funds for farmers impacted by weather disasters during calendar years 2020 and 2021. And $750 million of that was to go to livestock producers for losses incurred due to drought or wildfires in calendar year 21 through the Emergency Livestock Relief Program. And then through the Emergency Relief Program, the legislation also provided funding for non-insured crop losses that farmers incurred. Well, you had to have, as a crop farmer, let me focus on that side of it because that's where the controversy has been and the confusion has been. To be eligible for an ERP payment, you had to be a producer that had a crop eligible for crop insurance or the non-insurance crop disaster assistance program, that NAP program. And the crop for which you were seeking funds must have been subject to a qualifying disaster. That has a pretty broad definition to it. And the ERP payment cannot be made to a producer unless they receive crop insurance or a NAP payment in 2020 or 2021. So then they got into a very complicated formula in terms of how much of a payment you're actually entitled to when you're also receiving crop insurance. So your crop insurance premiums that an ERP recipient had paid are reimbursed by calculating the ERP payment based on a payment rate of 85%. Then you back out the crop insurance payment based on coverage level. So it gets really, really confusing. That's not the worst part of this. What was the troubling part was that there was a payment limit. The government farm program payment limit kicks in, and that's $125,000 for specialty crops, which we don't really worry about those in Kansas. We don't grow lentils and those types of things and sugar beets and all of that. But for other crops such as corn and soybeans and wheat, then there's a different payment limit. And if you have the bulk of your farm income or the bulk of your income come from farming, you could, for your non-specialty crops, double your payment limit, and for your specialty crops, take that $125,000 payment limit and get it up to $900,000. Well, there's that 75% test that's there. And so what became controversial was the definition of farm income for ERP purposes. And that's really where the rub was, and that's why this has made my top 10 list, is because of how that term was defined.
All right, let's go to number 9, and this was based off of a decision in the courts to not review the USDA Wetland certification, or in this case, the decision was upheld.
Yeah, usually we look at this from the opposite side of things, where you have a farmer that is complaining about the government exercising jurisdiction over their farmland, and of course, the new WOTUS rule, which is coming up in the list later this morning, gives the government greater jurisdiction to regulate farm activity. But here, under the Trump rule, the government concluded, no, we don't have jurisdiction over this farmland. And this actually has a longer history to it than just the Trump administration. This was back in 2011. This is a farming operation in southeastern South Dakota. And this fellow's got an 0.8 of an acre portion of a farm field that the USDA certified as a wetland in 2011 under the Swamp Buster provisions of the farm program. And what happened was his grandfather built a shelter belt planted a shelter belt in 1936. And of course, it's grown over the years, and it does its job. It protects the the buildings from wind erosion, and it protects the soil from soil erosion. Well, in South Dakota in the wintertime, it snows, and snow piles up against the trees, against the shelter belt, and then in the springtime it melts, and it creates a puddle, about an 1/8 of an acre puddle, about 8.5 inches deep at certain times during the year, and about half the time it will evaporate and soak into the soil, and he can farm it. Other years he has to drain that off to farm the field. Because it doesn't drain itself. It doesn't drain anywhere. It's just a puddle in the middle of the field. Well, the government came in. USDA asserted, well, that's a wetland, and you're subject to the Swamp Buster rules, and you can't drain that without losing your farm subsidies. And what happened in this instance was that the USDA refused to recertify, even though there was new evidence that was imposed, and even though the statute says that they're supposed to. And the trial court upheld the USDA determination on that in 2022, the Federal District Court for the Southern District of South Dakota. This one is on appeal to the 8th Circuit, so we'll see what the 8th Circuit says probably later in 2023.
Before we go to break, let's look at number 8. And this goes into the realm of Dicamba, but what we have ad nauseum discussed sometimes during this program, but for many years, and the concern about Dicamba drift, or in this case, damage litigation.
Yeah, this is the continuing saga, Greg, of Missouri's largest peach farming operation that has had some success, and quite a bit of success in courts, in claiming that their peach crop was damaged by drift from the spray of dicamba on surrounding farm fields. And in 2022, we had an 8th Circuit opinion dealing with the trial court's opinion of a couple of years earlier. When this case went to trial back in early 2020, it was more than 100 similar dicamba lawsuits. And Bayer, which acquired Monsanto in 2018 for $63 billion, announced in June of 2020 that it would settle dicamba lawsuits for up to $400 million. Well, this case was in the process, and what happened was that the trial court jury awarded the farm $15 million in compensatory damages and $250 million in punitive damages. That was against Monsanto for 2015 and 2016. And they determined that that Bayer and Monsanto were acting in a conspiracy, and again, you get damages because of that. And this works its way through the court system. BASF moves for a judgment as a matter of law on punitive damages or a motion for a new trial, and Monsanto moves for a judgment as a matter of law or a new trial. But the trial court said, no, you're both jointly liable, although they lowered the punitive damages to $60 million from $250 million because they said, well, the companies didn't actually have malice. They didn't have bad intent. The $15 million compensatory damage award was upheld. Well, it continues the companies appealed that. They filed their notice of appeal very late in 2020, and then we get the 8th Circuit opinion on appeal in 2022, and the appellate court partially affirmed the trial court, partially reversed, remanded the case, so it's not over. But the appellate court said the trial court incorrectly instructed the jury to assess punitive damages for Bayer and / Monsanto and BASF together rather than separately, and so you have to have a new trial to determine the punitive damages for each company. And the appellate court vacated the punitive damage award and remanded the case back to the trial court with instructions to hold a new trial on the punitive damages issue. But they did not disturb the jury verdict of $15 million in compensatory damages. So this will continue on the punitive damage issue, but that $15 million award for compensatory damages stands.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest as we're reviewing the top 10 as far as agricultural law and tax developments in 2022. We've gone 10, 9, and 8. We're up to number 7, Roger, and as you have stated throughout this entire time, the Inflation Reduction Act is another one, but as you have most definitely said, the Misnamed Inflation Reduction Act.
Yeah, exactly. I have this in the list is simply because of a lot of the funding that's put in there for ag programs. EQIP gets $8.45 billion additional funding over fiscal years 23 through 26. CSP gets $3.25 billion additional funding over that same time frame. The Ag Conservation Easement Program, $1.4 billion. $4 billion for drought relief. Now that prioritizes the Colorado Basin, so it kind of touches extreme southwest Kansas, but that's more in New Mexico, Arizona, Colorado area, southern Colorado. Forest Service gets $1.8 billion, $14 billion for rural development and lending projects, $3.1 billion to USDA for distressed borrowers, and another $5 billion for USDA National Forest System. And then the IRS, of course, this has received a lot of the attention, about $80 billion in IRS funding over the next 10 years to hire 87,000 agents. Now, we'll see if that ever happens. My problem with that is the bulk of that $80 billion is going to enforcement, and relatively very little is earmarked for IRS operations and to upgrade their taxpayer services, which is what's badly needed. And I've stated numerous times at seminars that I do that my preference would have been that they would have flipped that around. If you solve the taxpayer service issue and IRS education issue, then you don't need as many audits. But the problem that we run into, if they end up hiring that many more agents. Now, of course, it's not an increase in agents by 87,000. That's the number that's thrown out there. IRS is projecting they'll have 50,000 agents retire by the end of 2030, and so in the next 7 years they're going to lose 50,000. So you have to replace those. But when they hire new agents, those agents have to be trained. And often what happens is that they pull off the well-seasoned agents, the well-trained agents, those that understand farm issues off of the audit trail to train the newbies. And the other thing that we've seen historically is that new agents tend to be more aggressive in positions that they take. So it could create real problems for farmers and ranchers. We'll just have to watch that. But I have that in my list at number 7.
We go to number 6, and depending on the year and number of decisions, which normally we do have, the update on case law and legislative developments on specific ag-gag provisions.
Yeah, these are developments that have occurred across the country over the past several years, really. This has been ongoing for quite some time, where state legislatures try to provide some type of level of protection to livestock facilities in trying to bar access to, usually it's a confinement animal facility, under false pretenses. Don't lie to get a job and then do something that's illegal once you're inside the facility. And that would cause harm to the livestock operation. That's really what these are focused on. Well, there have been a lot of court developments. I'll pick on 2 of these, and legislative developments, but 2 of these in 2022. One involved the Iowa statute, and then the other development was the 10th Circuit decision involving the Kansas statute, which was struck down as unconstitutional. And on April 25 of 2022, the U.S. Supreme Court declined to hear the 10th Circuit case, and so that one stands. We'll see what the legislature does, if anything, about that.
And then, of course, number 5 is something we've discussed for quite some time. We'll continue to discuss for quite some time, and later, sometime this spring, winter, you name it. But of course, we're talking about the WOTUS final rule.
Yeah, that's exactly right. And this is something that the Corps of Engineers and the EPA put out right at the end of 2022. In fact, it was on December 30th. They came out with their final rule called the Revised Definition of Waters of the United States, which it seems, Greg, every time there's a change in administration, we get a revised rule. We apparently get some type of new revelation by the agencies that they hadn't thought of before, so they have to change their mind constantly, which really undercuts their credibility. So if the agencies are saying, and of course this is all supposed to be based on science and geology and hydrology and all of that, apparently all of that changes every couple of years. It's just amazing how happens. So it really undercuts the agency's credibility on all of this. But they did put out their final rule along with two joint memos with the final rule to set forth the delineation of the implementation of roles and responsibilities between the agencies. And one of those is a memo with USDA, which it says is intended to provide clarity on the agency's programs under the Clean Water Act and the Farm Bill, which means Swamp Buster. And when you read between the lines on that, it basically is saying, okay, USDA, we make the decisions and we tell you what the rules are going to be for purposes of Swamp Buster. That's another problem that's out there. I mean, the agencies, Corps and the EPA, have USDA under its thumb on this one. So those programs are supposed to stay separate. Congress never intended those to be pulled together, but they are under this. There are real problems in this for agriculture in terms of adjacency. The significant nexus test is coming back. Prior converted cropland. Now that one's interesting. Prior converted cropland is not jurisdictional at the federal level. And so here they came out and said, well, we want to clarify which waters are not jurisdictional, and that's prior converted cropland. Well, to me, that doesn't make much sense. How can you clarify that prior converted cropland, which is not a water, but somehow could be a water if the agencies hadn't clarified it? That makes no sense to me at all. Plus, the burden is on the landowner to prove that they have prior converted cropland that is actually not a water. There are problems with the rule in terms of the agencies, again, grabbing jurisdiction over ditches and drainage devices. Basically, any farmer that's got tile-drained farmland is subject to regulation potentially, and I think the target is on the back of those farmers that are in the prairie pothole region up in the Dakotas, Minnesota, parts of Iowa, have real problems with this. But keep in mind, Greg, there's the Sackett case that is presently before the U.S. Supreme Court, and we really are waiting on the Supreme Court to say what the scope of a water of the United States is. This rule doesn't take effect until March 20th. We may get the U.S. Supreme Court opinion before then, but it'll be awfully interesting to see what the Supreme Court says. Hopefully they'll clarify this. They didn't the last time they had a major case on this particular issue. Hopefully they will this time.
In other words, stay tuned, so to speak.
Exactly. Yep. Stay tuned.
All right. Well, that is 10 through 5. I am looking for 4, 3, 2, 1, which should be very interesting discussion-wise in the next couple of weeks. But, Roger, and by the way, they can find this list and talk in further detail on your blog?
On my blog, as well as on the Ag Manager website for the Ag Econ Department at K-State.
All right, sounds good. Roger, as always, a pleasure, and we'll talk to you in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. He joins us on the Ag Issues program here on 580 WIBW.